I'm Paula Brantner. My pronouns are she and her. And I have been working in the field of harassment, discrimination, and toxic workplaces for pretty much all of my career, which is getting close to 30 years now. And my background is as an employment lawyer. That's how I got started with this work. And early on in my career, I was involved with lawsuits on behalf of workers that had faced discrimination and harassment in the workplace. And after several years doing that, I joined the nonprofit sector. And for 18 years, I was with the nonprofit Workplace Fairness, which provides legal information to workers about their rights, primarily through a website at workplacefairness.org. And one of the things that I realized over the years of doing this work is that often there aren't a whole lot of remedies for people who have faced harassment and other misconduct at work, that the law is not really set up to provide great protections. And attorneys who work in this area only take a very small percentage of the cases that come to them. And so a lot of people are falling through the cracks. So when I started my consulting firm 4 years ago, which is PB Work Solutions, I really wanted to focus on people who were falling through the cracks and ways that I can make a difference and help people that weren't being well served by the legal system. And at the time, the EOC had just come out with a report talking about all of the ways that harassment laws had failed us, and basically saying what we needed to do is throw this all out and start all over again. And that was consistent with my experience of talking to literally thousands of people over the years. And so I wanted to be part of those solutions. So I've now been doing this for 4 years. And some of the recent work that I've been involved with, I am the National Harassment Grievance Officer for DSA, the Democratic Socialists of America. And several of you may know about DSA or may even be members, but DSA grew exponentially as a result of the rise of Bernie Sanders and the election of Trump, and went from about 6,000 members around the country to nearly 60,000 members in a very short period of time. And they had a harassment policy that had been passed by the membership, but they needed to bring it to life. And so I joined DSA a couple of years ago as the National Harassment Grievance Officer to build out their harassment and toxic prevention program. Some of the things I'll be talking about today reflect what I've learned from doing this for over 2 years. I also worked with Ultraviolet and Works in Progress to develop guidelines for political campaigns on what internal systems that they should have and set up to respond to workplace harassment and sexual violence. And those came out in early 19 as the presidential campaign was just getting going. But even now I continue to work with some of those same individuals on how we can strengthen systems for people who encounter discrimination, who encounter harassment in the political environment. Just a bit of housekeeping. This is Saturday. You've probably been through this drill. If you have any questions, use the Q&A and not the chat. I asked, when you ask questions, don't provide any identifying information about your employers or the organizations you're talking about. We don't want it to be focused on any one individual or any one situation. I welcome your feedback, and you can email me afterwards, or at the end I'll have all my contact information. I see here in the questions that I need to repost the link. So give me just a moment to do that. I want to make sure that you all have that. Okay, can everyone see the link now? Can you just let me know in chat if the link has shown up? Okay, great, great. Okay, let me get back to my screen here. So the quiz, which you can now see, has 6 parts, and this presentation will have 6 different parts. And so I ask that you fill out each part while I'm talking about that section, and that will explain the concepts that are covered in the quiz. What was a 75-minute presentation is now a 50-minute presentation, and so it's a little shorter than it has been in the past, but I want to make sure that we cover this and explain everything you need. And then you can disregard the last bullet point. We were having to tabulate it manually, but I figured out how to do it as a quiz, so it will calculate it for you and send it back at the end. So today we're going to talk about, first, what are the essential components of a harassment and toxic workplace prevention program? What are some of the best practices and key developments in the area? And this is moving beyond the nuts and bolts on policies, training, reporting, investigating, resolving reports of harassment, and accountability. And then I hope to leave you with some take-home strategies to improve any prevention program that you're involved with, whether it's at your workplace or any organizations that you're a part of or any political campaigns. And the goal is to leave this and understand how your organization or campaign or workplace measures up and where there is work to do. And so I'm hoping you'll work on the quiz as we go. That will really help you see where you compare to other organizations doing this work. So let's start with the first component, policies. You have to start with an anti-harassment policy. Those are often defined by federal, state, and local law. While it's not specifically required by federal law, it's obviously a really good idea. Many states do now require employers to have policies. And the typical policy defines what is harassment, what is illegal conduct, and it's usually historically been based on individual characteristics that are prohibited by law, such as sex and gender, or race, or religion, or national origin. I found that in doing this work, most entities, organizations, workplaces now have a policy. Some have had policies for over 30 years, but when the Me Too movement came along, a lot of people realized that they thought maybe they were too small to have a problem, or they just weren't organized. They didn't have a dedicated HR staff, or maybe it was a family business. They just didn't think that they needed one. But a lot of them found out that, yes, everyone needs one. Some even down to 1 or 2 employees under state law, it's required. If you want to go beyond nuts and bolts, I think an important thing to do is to cover categories that are not covered by the law. Go beyond the bare minimum. One of the things that you can do is include individuals or communities that are at a high risk of being targeted for harassment. And until June, I used to say that even if your state law did not cover sexual orientation or gender identity, that should be part of your policy. Thanks to the Bostock decision, Supreme Court decision that came down in June, which ruled that discrimination and harassment on the basis of either sexual orientation or gender identity are a form of prohibited sex discrimination. It's not necessary to break it out separately, as it may have been in before in states where that was not required, but it's still a good idea so that everyone knows what types of conduct and what types of anti-harassment and discrimination are protected. You may want to include the target populations of your work. If you focus on a particular community, you want to make sure that even if they're not protected by law, that they're protected from harassment within your organization. Many of the legal protections do not cover independent contractors or vendors. So one way to boost what you have is to include those categories of work. If you're in the nonprofit environment, you may have work with donors or funders. You may have volunteers, and those individuals should be subject to protections as well, whether it's your staff being protected by discrimination and harassment from donors and funders, or that anyone in your organization is not discriminating against someone who's a volunteer, an intern, someone who doesn't have those legal protections. If you really want to take it to where this should go, you want to have a code of conduct, or sometimes that's called workplace civility. And what a code of conduct does is it expresses the values of the organization, and it may even have affirmative values to be protected, positive ways that you treat each other instead of don't do this, don't do that, this is banned, this is prohibited. They're often focused on specific forms of conduct rather than the individual characteristics of the groups. So if there's types of conduct that are very disruptive to your work, you can name those. Similar to what NetReach Nation has with community guidelines, you can incorporate your community guidelines. You can cover conduct that takes place online, in meetings, off-site. It's not just limited to the physical parameters of a particular workplace or meetings of a particular organization. And that's really important right now with COVID and new ways of interacting and not physically meeting, but still there being opportunities to have discrimination. This is not based, it does not have to be based on or limited to the individual characteristics that I mentioned, which is one of the advantages. But really what they do is say that bullying and toxic behavior just don't belong in a professional environment. Oops, hang on. I'd like to move to component 2, and you should have finished the policies part of the quiz by now, because we're going to move on to training. Now, is harassment training required? It is not required under federal law. State and local law may require you to have training. And I think it's something that a lot of people have adopted. I think most major companies, and even now as a result of Me Too, much smaller companies and organizations have adopted it. If you don't do training, it may be a factor in legal liability in that you have not sufficiently trained your staff to know what is prohibited, and that can be used against you in a later lawsuit. But the one thing I'd like to caution is training is not the be-all and end-all. There's some evidence that training standing alone may make discrimination, the conduct worse. because you may have sat through a training where it talks about all of the specific ways that someone can do harm. And, you know, sometimes I've sat through these trainings, and it's like, ooh, I haven't thought of that one. If I were a bad person, I might want to, you know, add that to my repertoire. It's important to have training. A lot of people do, but it should not, you don't just do training and say, okay, that's it, we're done. The key components, you shouldn't just do the bare minimum required by law. You should do it on onboarding new employees so that they know what the values of the organization are. They should happen at least annually, if not more often. And don't postpone the trainings right now. You may not be physically interacting in person due to COVID, but as I mentioned, there are still ways that people are harassing and engaging in misconduct with each other. And so it's important to have these trainings even though you're not having that physical interaction. Training should be customized for your industry, your environment, your culture. And one way that you can really tailor that is to, before you do your training, do climate surveys that are either confidential or ideally anonymous, so that people can say, you know, what they're experiencing, what people need training on, what people need to know. If you do training with both managers and non-managers, you should have some sessions where everyone is present, where the expectations are conveyed to apply to everyone, but you should also have opportunities to separately address those groups of individuals. Managers should be trained on how to respond to reports of harassment, and non-managers should be in rooms where they can speak freely and not worry that they will face retaliation, or, you know, their boss will hear them commenting about their conduct. Oh, I did it again. You may be wondering, in terms of training, what can you do individually? If you're not the person in charge of this technique for the entire workplace, there are still things that you can do and learn in training to combat harassment. And one of them involves bystander intervention techniques. And trainings now should involve those bystander intervention strategies, and I could spend the whole 50 minutes and even more just on this, but the basics are, you should know who the bad actors are, listen to the Whisper Network and kind of know the people who are potentially problematic, know what to say, think about in advance what to say. If someone says something inappropriate, you can deflect it with humor, you can call it out, you can have a catchphrase. Mine is, wow, did you really just say that? Making clear that I'm a little gobsmacked by what was said. And, you know, everyone's different, you have a different personality, ways of interacting, but come up with something that you have ready and feel comfortable saying when the time arises. Know what to record, document, document, document. If something's happening to you, you know, make notes on your phone, take pictures, save documents, make notes. If you are present when someone else has encountered harassment or toxic behavior, you know, make notes so that if someone comes to you later, you can support what you experienced when this was happening. Know what to do next, whether to take it to a supervisor or, again, some of the other strategies that we'll be talking about later in terms of reporting. And the very best training, some workplaces have pioneered peer-to-peer training. And this is not an outside expert or consultant like myself doing the training, or someone within the company HR, but someone who knows and understands what the work environment is like. And this has been pioneered amongst farm workers, amongst janitors, some of the restaurants and bars, service industry positions, the best training are the people who understand the situations that people are likely to encounter. I keep grabbing my mouse, and that's not what I want to do. So at this point, you should be finished with the quiz on training. The next component is reporting. How do you report harassment when it happens? And it's not required that companies set up a specific way to report. But the flip side is that if you don't report to your employer and certain types of harassment, the employer is not aware of that, it could affect your lawsuit later. So you're in this catch-22 where you may not have a system set up to report, but you're expected to do it anyway. Luckily, some states and local laws are moving towards specific reporting requirements. And that is one of the post-Me Too developments that the various states have undertaken, is being very specific with what employers need to do. Again, it can be a factor in legal liability. And this is where I find where the process typically breaks down, in that people don't necessarily know where to report, how to report, or they fear reporting. And we've seen statistics that 80% of more people don't report because there's not a good way to do it. So when you develop a reporting policy, in terms of moving beyond the basic nuts and bolts, here's how you need to do it right. First, you need to have multiple points of contact. You want people to be able to go to their senior managers, to an HR department if you have one, or if there's a particular individual that plays an HR function, you should be able to go to that person, and you also should be able to go to your supervisor. You should also have access to multiple approaches. You should have a way to be able to report confidentially if you come forward, an assurance that your name will not be shared until and unless that's what you want to have happen. Or, even better, if there's a way to report anonymously without ever sharing who you are at all. You should be able to report verbally. I should be able to sit down with a supervisor and tell them what's going on. Or if I don't feel comfortable, safe doing that, the ability to submit something in writing. Employers and organizations should not require an official complaint, where we're not going to do anything with this unless you fill out a certain form and check all the boxes to make it official. Sometimes people just want to share what happened and explore whether they should do something further. And so you should not make it difficult for, rely on, a specific way that this has to happen. Okay. The gold standard is really third-party external reporting. And I will admit my particular bias is that is one of the services that I provide in my work. But even if you're not working with me, that is something that because of the way it breaks down, because of people who've experienced retaliation when they've come forward to someone in the hierarchy, reporting to someone who's not part of that political framework is ideal. A number of companies have developed apps to facilitate reporting, those apps allow you to fill out a form, and usually, like I said, you can do this anonymously or confidentially. Companies have, larger companies have been required to set up whistleblower or ethics hotlines under Sarbanes-Oxley, and so they've extended that to also include harassment incidents. But it's important that they not be directly affiliated with the company or an outside law firm, because otherwise it has some of the same problems where you don't necessarily know where it's going, who's going to act on the information, whether or not they can bury the information. I have a photo here of Amplify All Voices, which is my reporting system, but it's a way for someone to fill out a report, and that comes to me, and I interact with the person who filed a report before I take it to the company or organization who has hired me to provide this service. The next, and you should be through with reporting at this point on the quiz. We're going to move on to investigating. How do you investigate reports? This is where virtually everyone is getting it wrong. In most cases, they don't have something set up in advance, and they only announce what the process is going to be after there's a problem. And if you have internal HR employees doing this, are they well trained? Do they know what they're doing when it comes to investigating complaints? Are they going to be objective and neutral? What if they're part of the situation or part of the dynamic that is existing? The goal of the investigation is to get at what happened. It's not about doing the bare minimum to protect the company from liability. And so that is the real danger when you're doing it internally. How does the process work? This is again going beyond the nuts and bolts. You should share protocols in advance. Those should be transparent. When you get a report, you should investigate it in a timely, expedited fashion. You should do a thorough investigation, speaking with all of the relevant parties, looking at the relevant documents. You should protect the privacy of the parties in the process. And that, again, is often where employers have fallen down and subjected people to additional retaliation, or people fear coming forward and telling the truth because their participation in the process will not be protected. In terms of the proof, whether or not they believe someone, whether or not they find someone credible, the appropriate standard is the more likely than not preponderant standard. And that's not a criminal standard. You may have heard the beyond a reasonable doubt, or they're guilty of harassment, or they're not guilty of harassment, or they're innocent. The appropriate standard is the one applied in legal cases involving harassment, which is just a slight tip in favor of the person who reported is enough to believe them. And we've had to deal with a lot of tension between the he said, she said. What do you do if two people who are the only two witnesses to the situation report vastly different versions of what happened? Survivors have advocated for believe women. And, you know, there are people who think that those two things are in conflict. They're not. You can believe the woman or the person who comes forward with a report of discrimination, and they just have to be able to uphold this more likely than not, be, you know, slightly more believable than the other party. And that doesn't mean that you don't investigate. And if you do a thorough investigation, you will have a much better sense of who should be believed and who maybe is less credible. The gold standard with this is third-party independent investigations. And this is investigations conducted by people who are not affiliated with the company, not part of an outside law firm. Sometimes outside law firms are hired, and it's a very defense-oriented process where they do just enough to determine whether or not the company is likely to be sued. That's not good enough. They should have received specific training in workplace investigations, and there's a professional industry group called the Association of Workplace Investigators, which has standards for workplace investigation training. It should be trauma informed. People who understand the impact of trauma and what happens to people who have experienced harassment, sexual violence. And it needs to look at also how what the company did shaped the situation and how it may have contributed to an escalation of the harm caused by the discrimination. Did this person come forward? Did they report it? And the company didn't do anything. So it was a culture where it was allowed to thrive and continue. And I just have a couple of short stories that really highlight the importance of having independent investigations. And one is the story of Maha. And Maha is a graduate student at Dartmouth. And she had a fellowship. She was working with several professors in her graduate program. And the professor who was her advisor on 2 different occasions grabbed his genitals in front of her. And Maha said, you know, that was not appropriate. I'm going to report you. And after she said that she would report this conduct, another professor who was a colleague of her advisor retaliated against her and gave her a poor grade on an exam and a poor evaluation of her performance as a graduate student. She had asked, you know, she went to the university and they said, well, we've never had anyone complain about this before. Well, first she went to her department head and the department head didn't do anything to their 2 colleagues. And then she went to the Title IX office and was told by the Title IX officer that they never received any complaints about this person before. And these 2 incidents were not sufficient to constitute harassment. And so Maha was not satisfied with that. And, you know, she asked for an independent investigation. And Dartmouth said, nope, we've done enough. That's all we're doing. And so Maha began a hunger strike. And Maha announced at the end that she was a thin person. And, you know, on a hunger strike, her health could decline pretty quickly. And after she was on this hunger strike for a month without the university taking any action, she announced that she would begin, she would no longer, in addition to not eating, which she hadn't done for 4 weeks, she would stop drinking. And as we all know, that her health would decline very, very quickly when that happened. So at that point, Dartmouth finally relented. They hired an outside investigator, and it's someone who is specifically trained in doing harassment investigations and trauma-informed investigations. It shouldn't take a hunger strike to get that to happen. My other story is, excuse me, in preparing for this, as a lawyer, I take these continuing legal education courses. And I recently took one on Me Too updates just to make sure that I was covering everything I needed to. And these follow a typical format. And they have a plaintiff's lawyer representing the workers. They have a defense lawyer representing defendants. And they, you know, they alternate back and forth and comment on each other's presentation. And so the plaintiff's lawyer talked about some of the impacts of trauma, such as there can be memory gaps, and it's difficult to put together a timeline in serial order due to those memory gaps. And there's a tendency when you've been exposed to trauma to minimize the harm of what was caused and say it really wasn't that bad, it was really okay. And so the lawyer talked about, the need to understand this was happening when working with clients who have been harassed. Then the defense lawyer chimed in and she said, well, I didn't really think I needed to know anything about that because that trauma informed, that's just not something we think about. We just deal with the lawyer and, we don't really think about the impact of trauma on the victim, the survivor. But then she stopped herself and said, oh, well, actually, we are called in sometimes on investigations. And I guess this would be important if I'm, interviewing the person who was harassed in an investigation. And, I just couldn't believe it because, many times the company calls in its corporate lawyers to do the investigation. So if they don't even think about trauma or understand trauma, it's very easy for them to minimize the harassment that happened in the workplace. So it's really important to get someone who knows what they're doing and is not just trying to protect the company from liability. At this point, you should have completed section 4 of the quiz. We'll go on to component 5, which is resolving the reports with actual remedies. So what happens when you've gone through the report, you've gone through the investigation, and you found that the conduct violates the standards and policies that you have? You need to take immediate and proportionate corrective action. That action cannot create a burden on the person that is harmed. You can't make the person who experiences the harassment transfer them to another office to get them away from the harasser. It needs to, if there's a burden on anyone involved, it needs to be the person who engaged in wrongdoing. You have to monitor the situation closely and make sure that there's not retaliation. And what those corrective action, what the consequences should be, will vary with the severity of the violation and what the investigating body has the authority to do. If it's a workplace, they have the ability to discipline or even fire someone who's engaged in harassment. If it's a membership organization, they may be able to terminate their membership in a professional body. If it's at a meeting or conference in person, they may ask the person to leave the premises. There are different things you can do, but it does depend on the authority of the body doing the investigation. In terms of remedies and consequences, you want to think about who knows what about what happened. It's important to be as transparent as you can and communicate the outcome to those who reported the wrongdoing. And you can and you should, to the extent that the survivor wants to be involved in determining what is the appropriate consequences, to take their views into account. Did they, the survivor needs to know, were they found credible, or were they found more credible than the other party disputing the report? Was there corrective action taken as a result of that? And, this has often been challenging in the employment setting. Companies have said, well, that's a personnel matter. We can't tell you what happened. And so complaints just kind of go out into the ether and nobody knows, what the outcome was. I guess if they're fired and they no longer show up to work every day, you might know that. But anything short of that, often survivors were not made aware of it. And of course, play stupid games, win stupid prizes. If people in the workplace don't know what the outcome is, there's no incentive to report behavior because you have no incentive to know that anything will be done about it when that happens. Here's a way that you should not handle it. You should not force the person who reported, either as a settlement or in any aspect, whether they stay or whether they leave the workplace, to sign a non-disclosure agreement for any aspects of harassment or employee misconduct. You need to be able to tell your story. And a number of states have, in the wake of Me Too, changed their laws to prohibit non-disclosure agreements so that wrongdoing cannot be hidden and serial predators cannot keep doing what they're doing. You should not require arbitration to adjudicate matters relating to harassment or employee misconduct. And if you have no transparency as to what happened, where people knew that there was a process and the situation was dealt with appropriately, you're inviting, in essence, cancel culture. People will take this matter into their own hands. They'll talk about it on social media. They will do what I call trial by Twitter. And if you want to make sure that it's handled in a way that is pursuant to what the survivor wants and is the least harmful and disruptive within that workplace or within that organization, you need to have the transparency that will build trust in the process. One way to help with that, to make sure that the consequences match up with what you need, is a threat scale. And you can customize this for each organization. You take the most extreme actions, the most severe consequences for the most severe conduct. And over time, you'll develop some consistency, and you can show that you're not playing favorites, that certain people don't escape consequences or, let off the hook for their behavior. You could say, this is what we do when somebody does this behavior. And when it's really severe, we fire them. Or when it's less severe, we come up with some way of making sure that they've learned not to engage in that behavior in the future. You should be done with 5 now. We'll turn to 6, accountability. What does accountability from the top look like? Now, accountability may be at odds with the legal system. If you may have been told by your corporate counselor, deny, deny, deny. If you take some accountability, if you apologize, if you acknowledge that harm was done, that may make you liable in a lawsuit. But nonetheless, that's one of the problems with the legal system. It encourages those binary determinations and people fighting to the end in a very adversarial process. Talk is cheap. Harassment prevention is not. And so you have to allocate money to make sure that all the aspects of the system are in place. And you have to allocate time to make sure that people have the time to address these issues for training, to learn about the process. And if you don't have this level of accountability at the top, you really won't have it anywhere. So there are 3 prongs of accountability. Is there a proactive budget for harassment prevention? And that means it's part of the budget annually. It's not an emergency funding. It's like, oh no, we have a problem. We have to spend some money on this. We have to call our lawyers. We have to, drag somebody in to deal with this. If it's proactively funded every year, you know that you'll be taking the appropriate steps. Is sufficient time allowed to make it a priority? Set aside time for trainings, for staff to, require staff to set aside that time. If there are policies that need to be reviewed, decisions that need to be made, if it needs to be carved out as someone's job description, it should not be an afterthought, but it should be built in to the time you spend on other key initiatives in your workplace or organization. And how is leadership held accountable? Do you have to sue someone to get results? Do you have to threaten to or actually disclose things publicly before the leadership takes any action? Is the leadership willing to engage in restorative justice practices? And so by the values that they communicate in the workplace, they can indicate a willingness to be held accountable without an adversarial system. Wash, rinse, repeat. You have to do this over and over and over. You have to continually be looking at what you're doing and how you can improve it, implementing it as part of new employee orientation and mentoring so that people who come into the workplace have those values, conducting culture assessments so you can find out what's really going on and what you're not being told. After you've had a process, do a postmortem, what worked and what didn't. And what data do you need to determine whether this is actually working, and how do you measure what is a successful outcome? You need to have assessment in place for all of that. I'm going to leave you with 3 important principles. As you've seen from these 6 components, no one single component will be successful in isolation. All 6 of them are essential. When you put something like this into place, it will cause old issues to surface, and it will mean that new issues that arise will be dealt with promptly. So what success looks like means that your numbers will go up before they go down. Remember that it's a journey, not a destination. We may never end harassment completely, but we can reduce the harm that it does to the people who are targeted and the disruption in workplaces and organizations when it happens. So now it's time for the quiz. In the questions, I'd love to hear, I'm going to pull up the results, but if you have anything in the questions, any part you were surprised by or any takeaway, and I encourage you, if you want more information, you can use this link at the end of the quiz to sign up for my newsletter, my mailing list, for more information about harassment. So I'm first going to go to my quiz results, see how people did. Okay, we don't have a lot of folks that have filled out the quiz yet. I only have 1 response. That's 7 out of 60. So we know that there's a lot of work to be done in a workplace like that. And, you know, of course, I'd be happy to talk with you about that further. I encourage you to, you know, if you didn't have time or want to do it right now, that you, you know, go back to your workplaces and organizations and do that quiz if you're not doing it right now. I am going to turn to the questions. The question is, do we owe those who do harm an explanation for termination or removal from employment practices? And the question is, if you have an open and transparent process where it has been investigated, you should provide that outcome at the end of the process to all the parties, the person who reported and the person who was accused of doing harm. So yes. Regarding who knows what and accountability, we're dealing with a situation that seems more nuanced than the binary of a harm causer and a harm receiver. I'm curious, what about the person who caused the harm or the impact? And it's about a small local volunteer organization where a colleague was called and told, we've done an investigation, determined you violated your sexual harassment policy, we're removing you from our community. Colleague does not know what the behavior was, would like to repair harm if they can. If they can't, want to make sure that they know the behavior so they can't do it again somewhere else. Organization is worried that giving Z any information would be outing the person who's impacted. It's even more messy and nuanced than this, but in general, what room is there for transformative and healing justice in this work, and what responsibility is there to name and understand the harm or give some context for the removal? This is something that I have dealt with in DSA, and we created a process that did allow for confidential and anonymous complaints. And the way that we reconciled this is that we provide there's several steps in the process, but when it is being investigated, we provide enough information so that they know the type of harm that was engaged in and or that was reported. I don't like to say alleged because of the implications for that in the legal system, but they know enough about what is reported so that they can come up with a response. And then they are, once it's investigated, it is just, the outcome is decided upon by the leadership of the local DSA chapter, and they are given information that would allow them to appeal that to the national governing body of the organization. And so people can still come forward anonymously and share information without, you know, the kind of explicit detail that we've required in a criminal case or even a civil lawsuit. But there is definitely communication that allows people to know what the harm was and to have that dealt with. I have another question. Do you think sole proprietors need to have a policy? Who am I going to harass? Myself? Sole proprietors need to think about their first hire, and when they have something in place for the first person that they hire, that will create a culture. I suppose if they're always going to be a sole proprietor, they might not need one for themselves, but the question is, what organizations do you deal with and work with? Are you a member of a professional organization that could use a process? Meetings, conferences? Are you interacting with vendors or other organizations where there is harassing conduct, and you may want to, even in your contracts, put in a clause that allows you to terminate the contract if you experience harassment from the other party that you're working with. I've heard of independent contractors doing that. I think at this point, I'm gonna go back to the other screen share. Or no, there we go. Here is my contact information for anyone who wants to stay in touch. And if you complete the quiz, there is information on how to sign up for my newsletter and mailing list. And here are some of the links here to reach out, and be happy to talk with anyone privately, anything that they didn't want to share in a public and recorded setting. Happy to discuss this privately, and you know, we can set up a calendar call and be happy to talk to you. And let me just check the chat one more time. Where's my screen went away for that? Okay, I have a couple of things in chat I'll just add. It was really hard to take the quiz and listen to talk, so I didn't fill it out. Someone said, I realized I didn't know enough about our policies to fill out the survey. Yeah, I realize that it's a lot to do simultaneously, but you know, if you want to do it later or grab the link that allows you, if you grab the link in the app, the Netroots Nation app, you can, it's a hard copy of the quiz. It won't calculate your results, but you can kind of do it at your leisure and determine, it has the scoring key. So happy to talk about that afterwards. And I hope to see some of you around at later sessions, and hopefully we'll be meeting in person next time. Thanks, everyone. We are about to shut the room down. So if you need anything else, just follow up with me. Thank you.